encourage you to be able to put this out while I'm testifying. Yes, ma'am, I'm number 3. But because of our maps, yes, I'm going to submit this to you so you understand why my testimony is the way it is. Excuse me, I'm sorry. Anyway, these are maps of all these activities that we do religiously on Mount Hill. Okay, so I'll just bring this up there. I submitted testimony, but I'll be repeating it. But so you understand what I'm talking about, here's the map set. Carly.
Is there anybody here
It's up to you.
All right, thank you everyone. This is the afternoon session of the July 10 Board of Land and Natural Resources meeting. Thank you all for coming. We're going to be hearing agenda items C1 and C2 this afternoon. They are related issues, and we have people testifying. The people testifying on C1 and C2 are nearly identical. We are going to combine testimony for C1 and C2. The process is going to be that we're going to have staff presentation on C1. We'll have the board ask questions on C1. Then we're going to have the Attorney General's presentation on C2. Then we're going to have board questions on C2. And then we're going to go to public testimony. There's one person, number 16, Robin Cullen, who is on C1 but not on C2. So we'll have Robin first, and then we will go down the list in order, in the order signed up on C2. I guess I just want to start out by acknowledging that this is an emotional issue for a lot of people. But I want to first of all be really clear that C2 is an emergency rule. That means it's a 120-day rule. It doesn't mean it's an emergency permanent rule. It means it's a rule to deal with the situation for 120 days, and that is to provide the opportunity for a deeper dialogue on what the longer-term rules should be. So I just want to be clear, it's not a permanent rule, it's a 120-day rule to provide time for that dialogue. And so I want to I want to just ask everybody to be very respectful. We want to have a good public process. We want everybody to be heard. This is important for everyone to be able to say their piece. We have a lot of people, so we're going to have testimony for 3 minutes apiece, and I would ask everyone to please respect that. We'll have a timer here. You can keep an eye on it. When we get close to the 3-minute, I will give you a little heads up that it's time to wrap up, and I ask you to do this. So, again, I want to thank you all for being here. Thank you for participating in the process. It's a great statement that everyone cares enough to participate personally, and so thank you for being here, and thank you for joining us with us in a respectful process moving forward this afternoon. So with that said, I'm going to ask Scott Fretz to come up and present item C1.
Chair and members of the board, Scott Fretz, Acting Administrator with the Division of Forestry and Wildlife. Item C1 is a request for delegations of authority from the board to the chairperson, the administrator of the Division of Forestry and Wildlife, and the branch managers of the division to approve permits and authorize activities that are provided for in the hunting rules, chapters 13.122 and 13.123, Those are the game animal and game bird hunting rules. In putting together this request to the board, we've been careful to go through each of the delegations that we're requesting of you and to give consideration to each of those with respect to their significance and routineness. In general, our intention has been to request that those activities that are routine be delegated to the branch managers, that any permits or activities that are less routine or potentially impactful to resources or constituents delegated to the administrator, and for any permits that are uncommon, not routine, or impactful or controversial require approval by the chair. We've listed quite a number of these in the submittal, and I know you've read those and looked through those, so in the interest of time, I will leave that to you and be standing by for any questions that you may have.
Thank you. Okay, questions from Scott at this time? No questions? Okay, thank you, Scott. Mr. Chin, do you want to present on item C2?
Aloha Chair, Board members, Doug Chin, Attorney General. Today is an opportunity for the board, in the words of an editorial yesterday, to assert some needed controls over the summit zone at Mauna Kea. After receiving testimony, the department respectfully asks this board to find credible evidence in the record to indicate that an imminent peril exists to public health, safety, and morals for which quick action is necessary. I will highlight just a few. First, the intentional placement of boulders and rock walls into a road under the board's jurisdiction that is steeply graded, graveled, and has significant drop-offs on the side. Second, the prolonged presence of people at all hours of the night, positioning themselves inside, on top of, and an obstruction of the sole roadway to the summit. This road has no lights, no guardrails, no markings, and no sidewalks. Third, repeated examples of individuals acting in disregard of the color of authority, forest rangers, field care officers, and police, leading to more than 40 arrests in 2 days. Finally, harassment and violent threats to the point that current public and private workers who are required to access the road do not feel safe enough to report to work. For 4 months now, these actions, by themselves or altogether, have been coordinated, induced, strengthened, and supported by a 24-hour presence of individuals who do not have a permit to reside there for any period of time. These are forest reserve lands. This is a hunting and gaming area. They cook there, they sleep there, they live there. I was at the visitor center yesterday and want you to know that even with notice that the board is talking about this rule, in the past 48 hours alone, individuals have erected a very large luxury tent, the largest of all of their structures by far, without a permit and against DLNR regulations. And for these reasons, the department recommends that the board temporarily adopt this rule for 120 days to mitigate these threats and in due course restore normal public access to the summit. We have a proposed amended rule that we've put together that is also based upon comments that we've received from the public, the testimony that has already come in. But essentially, that amended rule sets the nighttime hours. Yeah, we can put that up.
Does that just come up?
Yeah.
All right, so as everyone can see, and I think it's being shown outside too, it describes the restricted area. It also describes the prohibited items that would be not allowed, sleeping bag, tent camping, stove, or propane burners. And then basically it restricts hours from 10 to 4 a.m. Except for the exception. I've spoken for 3 minutes and 17 seconds, so thank you very much. I'll take your questions.
Thank you. All right, questions? Mr. Chin. I guess I'll start.
Sure.
And I just want to just confirm with you that this is 120 days.
That's correct. In other words, the way that this kind of is, it's actually not called emergency rulemaking, but the way that this rule applies within the Blnr's administration, excuse me, within Chapter 91, is that if there is an imminent peril to public health, safety, or morals, then the board is able to pass a rule after an expedited hearing that's good for 120 days. It seems like in this situation, this would be an appropriate application for the board to be able to find would be a use of this rule. In other words, the last 4 months, the very drastic change in circumstances that's occurred at Mauna Kea, and the importance of being able to reestablish some order as the difficult situation continues. Thank
you. And can you just explain, is camping prohibited already on the mountain?
Camping is it is not allowed under the forest reserve rules, and it is also not allowed under the game mammal hunting area rules. And it is also true that these people are there, present on the site without a permit. The problem has been that the assertion that I think you will hear from people today as they're testifying is that they're not camping. They're doing other things. They're either parked in their cars, they're chilling, they're hanging out, doing other things, but it doesn't actually constitute camping. And so what we feel is that what's really at risk is the prolonged excessive use that's been existing in this area, but is actually not equipped for camping or for any other extra purposes like that. And so what these rules do is they clarify basically a restricted time when nobody can be there within the area unless they're transiting, and also not be in possession of certain camping-related equipment. I don't know a better way to describe it, but it's essentially that kind of materials.
Besides these rules that we have in front of us that we want to put for emergency or for the next 120 days, have you or the department looked at any other avenues, any other options besides implementing these?
Sure. I think the difficult part about having people residing there where there is different ways to interpret camping is that's exactly why we're trying to insert more clear language that actually prohibits a certain kind of action of just being in the area or having certain types of items. As far as other types of criminal or civil penalties, the types that would be available would be citing them for unpermitted structures. For example, portable toilets were brought into the area and placed in Monteo and our lands. The Department of Land and Natural Resources sent a notice of violation to the commercial owner for operating for commercial activities in that area. So there's that. There's also the typical criminal statutes that are in existence, such as obstructing a roadway, failure to provide ingress and egress, and all of those are options within law enforcement should they decide to enforce it.
I have somewhat of a problem, only because I know what you're saying, I understand that, I'm on the fence, but I do have feelings for the other segments of people who want to go up to and view or relax, or their way of just expressing, look at the stars, or the school children, or maybe they have to go up at 10 o'clock at night or 12 because there's something that they want to see. I just have an issue if we ban this for the next 4 months. How does it reflect on them or other entities?
Sure.
And I don't think we should be singling out one person or the other, or one group or the other.
Well, Member Rose, I understand your concern, and I agree. I think if the board were to make this decision to adopt this emergency rule, it does place that the rule applies to everyone in terms of what they can not bring into the area, and as as well as their ability to remain present within the restricted area, unless they're an existing.
But could that group ask a chairperson or a branch or something like for a certain permit to go up at that time?
The way the rule is written now, it wouldn't allow that. It would just be, it is just closing, it's closing the time. I think the other way to look at it is that this rule takes into account a limited time period. In other words, I think the earlier version of the rule that was posted had the start time at 8 o'clock. And I think this is a little more, this is a later time, which allows people to be able to at least be able to enjoy the facilities for a couple hours before nightfall and before the late time. Thank you. Thank you. I have a correction, and that is that actually, even though there are prohibited rules, there are rules that would be in place, such as this one, that would prohibit certain activities. The board is able to, or the department is able to issue permits if that's the case. So I apologize for not having that nuance now.
I have a question. What's the overlap between these DLNR rules and the Office of Monetary Management
Oh,
rules?
thank you. So, in other words, here's how this board can look like. Before I do that, let me just finish one thing with Member Gomes, because I realized that I was starting to talk about how it's a burden if this rule is passed. I think we can all concede and acknowledge. I think the board would understandably have the right to be concerned about that. I think the concern on the other end that we're simply asking the board to consider is the balancing of public safety and the types of activities and events that have been occurring up there on the mountain. So that was the only last part that I wanted to share, is that it is a balancing test. So we are asking the board to make that consideration. That's why I advocated for it. Okay. Remember what side you were asking?
I was asking about the relationship
Oh,
between
yes,
this rule that we're looking at and Office of
Right.
Monetary Management.
Right. This board has jurisdiction over the forest reserve area as well as the game mammal hunting area. And so within those DLNR lands, UH, or through the Office of Monetary Management, has a lease agreement that the board approved several years ago that allows it to be able to use its management area as a science reserve. And so within that, think of it like a lease agreement. So within that lease agreement, there's what's called a comprehensive management plan. And so it has certain terms within it. And part of those terms is that the Office of Monetary Management does have authority to close the roads if there's a public safety issue or if there's other hazards. So examples, as I understand, for how the Office of Monetary Management has closed the road in the past would be, for example, a snowstorm or some other natural occurrence, as well as other concerns about the safety of the roadway. Keep in mind, what we're talking about, a partially graded gravel road, steep grade, going up for 6 miles from the visitor center up to the summit. No guardrails, no markings, no sidewalks. It has a steep drop-off in many of its locations. So that was a lot of the concern that I think was being raised by different people who were, and I think we'll hear that as well in the testimony, is that this really isn't an area that's equipped for that kind of prolonged and excessive use that's been existing. And that is something that the board should consider is the amount of overuse that has been.
So as a follow-up to that, if I look at the amended rules that we have in front of us now, and in my mind, the intention is that from 4 a.m. to 10 p.m., there isn't this restricted
Correct.
Time period, but Office of Monetary Management can choose to say that they will further restrict access to a limited time and a limited number of people.
Right.
So they can, even though we have an intention that
Right.
maybe it would be open for different times,
Right.
that they can
No,
look
that's-
at something different, and we don't have any, that's not within our Kuleana to look at.
Right. So that's a good point. In other words, there's overlapping jurisdictions. The state's ability to enforce might be more, it might be more practical for the state to be able to enforce if it's enforcing its own rules rather than a contractual term that's within the lease agreement.
Thank you.
Thank you.
Go ahead, Stan.
Go ahead.
I have another, listening or hearing that, how do, since there's overlapping, University of Hawaii and state,
I want to make sure people can hear. So can you move
Yep,
the mic?
I got it.
Actually, you get it closer and we'll just move the mic.
I'll just talk louder.
Yeah.
Basically, how would you, or how would the University of Hawaii, Blnr, would address for religious purposes? Because we have some religious freedom acts to deal with, and
Absolutely.
how do you, and especially if it's a period of 10 and 4, and you have these practices that want to be observed, or how do you address that thing?
Thank you for your question. I mean, I think that's a good question, first of all, for as far as UH and the Office of Monarchy and Management is concerned. When they're up here testifying, I'd urge the board to ask them what are their practices and, or what is their policy in terms of understanding and respecting people's traditional and customary practices. As far as the Board of Land and Natural Resources is concerned and these DLNR rules, what we would argue is that these rules still allow access between 4 a.m. and 10 p.m. So there is time to be able to engage in those traditional and customary practices. So the argument would be that there actually is a reasonable window of opportunity that's being allowed for people to use. The time that's accepted is sort of this breathing room time between 10 p.m. and 4 a.m. I think that I guess the best way to describe this is, and I've really been, because I think about the testimony and I think about what input that we're getting from all the different people who are interested in this issue, and the best way that I can come up with that I want to just share with the board, in layman's terms, it ultimately becomes a balancing test. Like in other words, people do have, and it's recognized within our Constitution that we give, that we recognize Native Hawaiian. In fact, I think I wrote a slide, I made a slide that shows the constitutional provision. I think it'll help the members of the board to be able to see it, because essentially it refers to the importance of understanding and respecting people's rights for cultural and religious purposes. And it says for Ahupua'a, tenants or descendants of Native Hawaiians who inhabited the Hawaiian Islands prior to 1778. And at the very end of the constitutional provision, it says subject to the right of the state to regulate such rights. And so the best way to look at it is that, for example, when it comes to public safety, someone might have a right to practice their religion, a customary traditional right. But that doesn't automatically mean it's an absolute right that trumps over everything else that's out there. It's subject to the right of the state to assert its own concerns. It's a way of recognizing the entire community. Not to say that this, I mean, this is a special recognition, but it's also an understanding that everybody and everybody's concerns need to be dealt with.
So in 4 months, 120 days. After the 120 days, if there's no resolution on both sides, or people's other minds come to the table, what happens then?
Right. Well, I think this. In other words, I'd urge the board. I'd urge the board to continue tracking this. Bring us back to the table. Have us talk about, what is the situation. Give a status update as far as what's happening in Blnr Ag. Ask questions during that time. The point of having temporary rules such as this for 120 days is that under normal circumstances, what you might do, like with the sea cucumber emergency rule that the board passed a couple weeks ago, is you would have this rule in place, and then if it's working or if it's useful, then the board could start looking or considering permanent rules, or it could look at lesser rules or smaller rules. You know, the point of having a temporary rule such as this is that it allows time for the board to consider what it wants to do during that time. And I, you know, we, the department, would be happy to keep the board apprised of how it's going.
Thanks. I'll wait. I'll let more of the other members.
Sir, thank you.
Mr. Ag.
Yes.
Thank you, Chairman. I live in Keaukaha, and across the street from us, we have part of our ohana, with about a couple hundred Hawaiians in our ohana. And we have a Filipino, Chinese.
Sorry, I think we need to move the-
Oh, sorry.
usually pretty loud.
Yeah. Chairwoman knows
Gotcha.
me, she knows me pretty good. So, our grandson is Cabello. And he's Chinese like you, Hawaiian, Filipino, Portuguese like me, and Cherokee from my wife. So, I'm on both sides of the line. So the area that I'm most concerned about is what is going to be the result of all of this. And down in the hood where we live, maybe we're split down the middle, but one thing I think that everybody down where I live believes is pono, and that is that we have Hawaiian children education and give them an opportunity to go to college. And everybody, I think, would agree that that's a good idea. So out of this whole thing, if we're gonna go through all this burn, all this agony, and all this confrontation, I hope that the message is clear from us that you better do something to make this thing good, especially the governor and the president of the university in particular. We expect you folks to do a good job to make education more available to my grandson. So that's where I'm coming from. One area I don't care for that I hear about, and I want you to give me some specific. I want to know about what kind of threats are going down.
Right.
I don't approve of that.
Right.
I'm a lawyer. I took an oath to uphold the law. And sitting over here, we got to do what's best for everybody in the community. What kind of threats you have?
Right. Right.
I want to hear some details.
Right. I think that'll it'll come directly from the people at UH who are going to be testifying about that. But what I want to share about those threats, about the rocks in the road, about the rock walls.
I'm not concerned so much as the rocks as I am on the threats.
Right.
Because I have my own threats. When I went up there, just when I got sworn in as DLNR, I went up there the first time when the protest was, and we had some Makuli Oriental scientists, and the one gentleman standing next to me was walking with a cane. And when he tried to go forward, one of the protesters right next to me spit in his face. I didn't care for that. And that's the day I decided, we got to fix this thing up here. This thing is a mess. So I'd like you to hear comments on that.
If you want to know how it is, why am I here? Why am I asking this board to pass this emergency rule? For me, I mean, for you, it was the threats. You know, I think for a lot of people who care about law enforcement, what was significant to us was when we saw rocks appear in the roadway. You know, and I realize that's not the same as the threats, but that June 24th really, sadly, it changed what seemed to be getting accomplished, which was a lawful exercise of people's First Amendment rights, which was something that should be respected, something that should be applauded. In fact, the zeal and fervor that so many people have about this subject it's healthy, for the community to go through something like that. What is absolutely unhealthy is instances that apparently are not under every people's control, where people are issuing threats or blocking the roadway in a way that endangers public safety. That's where that's where I think the pivot occurred, and things needed to change, and that's why we're here.
Okay, thank you.
Sir, thank you very much.
Other questions?
We know that there are a lot of, I'm sorry, we know that there are a lot of people here, a lot of people who submitted testimony, who are very passionately against the construction of the 30-meter telescope. What will they be able to protest on the mountain if these rules are passed? And to what extent would they be able to?
Sure. If the rules are passed, then people can be present. It's not talking about who can protest or who cannot. I mean, ultimately, people have a right to be able to lawfully exercise their First Amendment rights. What this restriction would do, when the board has fairly broad authority over its own lands, what it can or cannot do, is it will basically say that between 4 a.m. from 4 a.m. well, for the most part, well before sunrise, to 10 p.m. Those practices, those lawful exercises, can continue, and they can happen.
So people can stand off to the side, on the side of the road and hold signs, for example,
Correct.
chant.
Correct. And in fact, I think one of the things that we've tried to recognize in fairness is that there are many individuals who've done exactly that. And what is unfortunate and well, just troubling about June 24th was that even with people who were trying to exercise their lawful rights to First Amendment, so basically following the law, that there were people who even this group could not control. And when I say people, it's not just a few people. If you look at the pictures of the rocks that were along the entire area, that's not just 2 or 3 people. That is a significant number of people that were violating the law and creating a public safety hazard. And so that was a difficult situation.
And so, I have a question also related to the 30-meter telescope about the existing legal status or the existing legal situation. And because I read, basically I'm getting this in the newspaper, but some of the people who are opposed to the telescope say that the construction truck should not go up while there's an appeal pending of the Conservation District Use Permit that was issued a little over 2 years ago by the Blnr. What is the legal status?
Right.
Why do the construction trucks have the legal right to go forward, and what would change that?
I think that would be, and I've heard that, and I heard the comment that basically no activity should take place or go forward until basically all legal remedies have been exhausted. What I can say is that, I don't know if we'd ever live in a world, we'd ever be able to get to a world like that where you have to wait until everything was completely resolved all the way. I think the reality is that what happens, and I'm going to start speaking like a lawyer, is that the portion in time when someone gets the right to be able to move forward is when the board issues its permit or issues its authority to go, and then the trial court affirmed that. So when the trial court on the Big Island said it's okay for you to proceed with your permit, I'm affirming the Board of Land and Natural Resources decision with the permit. They had the right to start constructing then. The Supreme Court, it went up to the ICA. It's now in front of the Supreme Court. That is the appropriate place to resolve this dispute. Legally speaking, whatever the Supreme Court decides, then they will decide that at that time. They come in, that you know, the arguments will be next month. Decision could come out you know, sometime next year. There is no, and that's the reality. There, as you know, there is no guarantee when the Supreme Court will rule on an issue. But in the meantime, that doesn't stop the legal right that people have to exercise the order that they have. I'm going to use, well, I know I'm going to get in trouble for using a terrible, the analogy that, and I guess it's because I think of it as a prosecutor. It's just that sometimes when people get convicted, they're convicted, right? Their appeal might get them overturned later on, but the conviction has occurred already. So that's a terrible analogy. I probably, you know, it's probably not very useful, but that's the idea. And I guess as an officer of the court, as somebody who's supposed to uphold the laws, we have to respect whether we agree or not. I'm not sharing. You know, it's not a personal opinion of what TMT can do or cannot do, what UH can do or cannot do. They have a permit that allows them to be able to start construction, and so that should be occurring.
So it's my understanding that there are parties in court opposed to a
Yes.
30-meter telescope. It's my understanding that there is a legal mechanism before the appeal is decided, a stay or an injunction.
Right. That's exactly right.
That has never been issued.
That's correct. In other words, the plaintiffs to this appeal could have, under the rules, they could have asked the Supreme Court to stay the permit going forward pending appeal. They've never asked for that. So what are we, you know, what do we do at that point in time? We have an entity that has a lawful permit to go forward and start constructing, and we have the need to uphold public safety and uphold the laws. So that is the situation that we're in.
Well, if a stay was issued and the TMT went ahead and ignored the stay and started to build, we would stop them.
We would stop them, because that's not right.
That's all the questions.
Right. Thank you, sir.
Okay, Mr. Rory.
Yes, sir.
Just to follow up on that, I don't think it's quite as simple what the Supreme Court of Hawaii says. The 30-meter has a property right in their sublease, right? They have a right to utilize the road and have a right to get there,
Yes.
all right? They have that sublease in place right this minute. So they have a property right. In the grant of the CDUP, I don't know that that's a contract right or a property right or both, but it is at least a contractual right that gives them the entitlement to due process of law. And as long as they have the lease and as long as they have that contract right, they have a right to use the road, public road, like all of the rest of us, and go up to their property. Just the same as we can go to our house, and nobody can block the road to our house. Or go to our place of work, and you can't go block the road to your place of work. So, I'm troubled by this idea that it ends at the that state Supreme Court, because I don't think it ends there. I think this whole thing ends at the U.S. Supreme Court. Because whether the state prevails in this particular case, or the protesters prevail, there is a certiorari writ that's available at the state Supreme Court. And there's a certiorari available if any of the contestants want to go to federal district court here in Hawaii. And there's a case filed right now, I understand it. One in state court, one in federal court. I don't know what's going to happen with it, but I think we all should understand clearly, Mr. Attorney General, that we be careful what we wish for. Because if this goes to the U.S. Supreme Court, based on the composition of the court, we may lose our pass rights. Because Rice versus Cayetano has got some very strong language in it about giving preference to different nationalities and his historical, ancestral rights and that sort of thing. Very strong language, and I just read it yesterday for the third time to make sure that when I said that to you, that I knew what I was talking about. So I'm hopeful about this whole thing. All the last 45 years, I represented all my Hawaiian friends against the plantations, the state, everybody under the sun. And one of the things that I utilized was pass rights. And this pass rights is teetering right now. And everybody in this room better understand that. So that's why I think e aho mako e kuka mua i kia manawa. Oia ka mea polole i kia la. A oli haka vale no o kia ka la no ka no mai ka iana ka apuni ki o honu ne. It's a good time to negotiate and think seriously about where we're all headed. Because we're all together. We're all one people.
Sir, thank you.
I have a question about your, sorry, I'm not cutting if I need this.
No, go ahead.
I'm up
Okay.
for now.
I have a question about your comment about between 4 a.m. and 10 a.m. is enough time for cultural practice or
4 a.m. to
religious.
10 p.m.
Yeah, and I just wanted to follow up hypothetical sort of questions, and I apologize for putting them hypothetical sort of questions, but if the department, microphone, sorry. If the department did want to issue a religious practices permit to somebody during those evening hours, am I correct that the Office of Mauna Kea Management could choose not to allow those practitioners to conduct their ceremonies in those evening hours?
I don't know the answer to that, only because I think that the Office of Mauna Kea, because I think what you're concerned about is that the answer would be, yes, they also have to get permission from the Office of Mauna Kea Management, but I think it might depend on what is existing in the agreement between Office of Mauna Kea Management
And DLNR.
and DLNR.
That was one of my questions, was to better
Right.
understand what those agreements are. And it says,
Right.
I don't know, communications and agreements that we've had between DLNR and Office of Mauna Kea Management. I wanted to understand what that was.
I mean,
Sorry,
no,
go ahead.
I was just going to say that what I have seen happen, a sense of it is that the people who are out there, the Office of Mauna Kea Management, as well as the DLNR folks, they're aware of the different situations, and they are trying to work together.
Part of my concern is where, if in 120 days, during that time period, we're moving into Piko Wakea, and I know you said that, between 4 a.m. and 10 p.m. is enough time to practice, but there's, 3 ceremonial times that you are completely out of the question. If you choose those times, there's 3 ceremonial times that we can't practice, and there are Piko Wakeas coming up during this time. So I want to understand how do we ensure that that can occur, if these emergency rules do get passed for the next 120 days. There are other things that happen, but that's a big one that happens during these next 120 days. And so how do we ensure that we can still do that on Piko Wakea for those days that it covers, for the times of, Popili Ko, Popili Puka, all of that happens in those evening hours there. How do we make sure that we can enable that to happen?
And I appreciate the fact that you were you're thinking about all those different scenarios that could come up, because I think that those would be those are the right questions to ask in terms of being able to respect that. Thank you.
I have one more follow-up,
Sure,
kind of
no
on
problem.
on a different tangent. I think after June 24th and the rocks and the ahu on the road, many may have realized that a line was crossed. Since that time, have there been similar incidents to that? What has been the communication and the response and the follow-up since that time?
That there have been volunteers that came in, many of them who were from the, who identified themselves as people who lawfully exercise their First Amendment rights, who helped clean up the rocks. I think there was remorse that was expressed for them. I mean, I think the concern that I have, and I think you might be hearing this from some of the people who are testifying today, is just that it's not enough. It's not enough to just be hearing, we've cleaned it up, so don't worry, it's not going to happen again. Because what has occurred is there's been statements saying, well, we're going to do whatever it takes to make sure that, and I'm paraphrasing, but statements like, we'll do whatever it takes, to stop such and such. So in this case, it's the construction of
come from
TMT.
both sides, but
Right. Well,
to be fair,
good point.
I think those
But
statements come from both
and
sides.
I think that, but I think that that's the concern, is that if that's the case, then to the people who are working there, and as board members with a fiduciary duty to prevent any sort of liabilities that could occur, it's very important to think about that we want this to be a place that is going to be ultimately a safe open access for all. I was actually thinking about something when Member Rohr was speaking about his his vision for what it would be like, and I think ultimately where you want to be is you want to be at a place where the road is accessed safely, and people who want to exercise their First Amendment rights lawfully are able to do so, and people who are not doing that can be effectively prosecuted, and effective enforcement can take place against them. Essentially, that's what this request for emergency rules is about. Is trying to ultimately it's to get us there, and not simply to just get us through the next 4 months. So, thank you.
A question to what you just said. The existing rules that we have now, that's not good enough if we were to enforce what we have now, that we need to implement these?
Right.
Because that's what I'm gathering.
What's missing, to my mind, and I came from being a prosecutor, so I think in terms of, what do you need in order to be able to effectively or adequately have the right grounds to be able to charge someone, because that's a serious thing. You want to make sure you do it correctly. And what's missing is a certain amount of clarity that comes to what camping would be. And so that's why what these rules do is, rather than just refer to the concept of camping, it talks about, it removes the conduct of staying overnight, being there for, essentially it would make it impractical to be able to be there for overnight or for any prolonged. It's not
But the present rules you have now, it doesn't allow camping.
It doesn't. It doesn't.
So
The problem is that the assertion is that, and there's case law within the Hawaii Supreme Court cases that have come down that have really challenged, what does it mean to be park closures? What does it mean to be in camping illegally? That sort of thing. And so I guess the best way that I can say it is that as a practitioner, it's more clear if the board can be able to put out rules that talk about a certain time or certain items that cannot be brought into the area versus just saying you can't camp. So if somebody's parked in their car and they happen to doze off camping, well, they can doze off for 6 hours. They can't, like that kind of thing. That's where it becomes vague. but the types of rules that are being introduced here would make that kind of question more clear. Yes. Oh, I think
Mr. Oy.
yeah.
Okay, you know,
Sorry.
as far as the, that's a hunting area.
Yes.
Sorry, can you put the mic over there?
It's a hunting area, and with the rules that you're implementing now, you have to stay 1 mile both sides of the road. I know in the hunting area, right now I think about 50 yards on both sides of the road.
Is a safety zone.
Yeah, it's a safety zone.
Right.
So, what are you know, what you're doing is you're hurting the hunters. And the hunters, you know, a lot of them, you know, up there just to do hunting, you know. So, you know, this issue here is hurting a lot of people that's not really involved in trying to stop that telescope. You're hurting the whole community. And you shouldn't, you know, something like this shouldn't be happening where to punish one group, be punishing the whole island. You know, there's other methods. I look at the hunting, what's that, Title 13, Chapter 213, and it says already you cannot camp in hunting in a hunting area. I talked to my the forest chief on Kauai and says you can't, you know, the only way you can is in permitted area. And is there a permitted area up there?
Correct. So the entire hunting area is 70,978.
Yeah, and I was told that there's no permitted camping area within that area.
You cannot camp in there without a permit, right?
They don't issue permits to camp in there within the monarchy zone. So what's the problem if there's restrictions already?
Right. The problem is.
Yeah, I can, you know, I can understand what you're saying, but, you know, yeah, for me, I look at the whole community.
Right.
You know, you gotta, you know, it's good to like this is a temporary rule, but then I look at C1 and under 1322.11.9, if that passes, the chairperson can stop, close or restrict use of public hunting areas for 6 months.
Right. And the reason why that rule is.
So this thing can go.
Yeah.
This thing can go 4 months and it's almost a year.
Right.
You know,
I'll tell you the reason why a previous board came up with that rule, as far as the authorized rep is concerned, is because they actually can't just do it for no reason at all. There's a list of requirements, and so one of those is if there's a public safety.
Yeah,
Right.
that's
Right. Right. Public safety or a threat to natural resources, and so at some point in time, the contemplation of this board was realizing, you know, these lands that is within this board's kuleana is something that has to be protected, and it is considering those. Remember, I'm glad that you're considering all of those issues.
Because to me, you know, there are rules in place already. You know, if they can circumvent the rules, they're good. You know what I mean?
I wouldn't agree with that. I think the better thing to do
But
is,
how would you think?
and I will say, it's because there is no, we would never be in front of here if it wasn't for just the situations that have occurred. And I think, you know, what you will be hearing in terms of the incidents that have taken place, the threats, you know, the rocks in the road, the harassment, the bullying, the vandalism.
That's what, you know, for me, you know, I'm not siding with. Well, I sided with the hunters and the public that
Right.
want to use the mountain. You know what I mean? But you know, like there's certain areas where they stop the contractor from going up the hill, or even putting boulders on the road. You know, that's health and safety. And aren't they doing, you're doing more destruction to the mountain than good? Especially when you don't let the contractor go up to his equipment to resolve problems with the equipment. Who then is creating a problem in the mountain?
Just for your understanding, by my calculation, the restricted area is about 1/6 of the entire area that's covered by this.
1/6 of 70,000 acres.
Correct.
How much is that, about 18,000 acres?
No, 12.
12,000 acres? That's quite a bit. Back to member Owe though, I can sympathize with you, Tony, because I felt that with these modest restrictions, how will it hurt the public? And what are the economic consequences and the impact of other public segments that will be affected? And that's where I'm at. I hear you loud and clear.
Right. And I suppose the other option that the board does have is just that it is able to, that's exactly the reason why this discussion is occurring, so that the board can determine what it wants to do with this rule, whether it wants to adopt or not adopt it or amend it.
That's when I was asking if there was other options,
Because I do hunting, I go to Lanai twice a year to hunt sheep and deer. And we have the same area. And the area we hunt on is, I would say, not even 200 yards from the road.
Right.
So, the distance from the road, the hunting area is the same as fishing. You go an area that you can catch fish. There's certain areas that you can hunt where you can pick up game. You can't speak on the basis that it's only, so many the areas that. If the game is there, then.
Right. The restricted area is only in effect between 10 p.m. and 4 a.m. And there also is a transiting exception.
I understand that.
Thanks for thinking about it.
Mr. Rodriguez.
When I was younger, I went to the Hawaiian Language College for 7 years. And we had speech giving every week for the whole time I was there. And I remember early on, I don't remember whether it was second year or third year, one of the young gals in our class who was on the softball team, she brought a rock to class. And she was discussing with us that inside her rock was an uhane. And she would talk to her rock when she was feeling hopo from going to class and she wasn't doing so good, and baseball and class wasn't mixing too good. So it was ingrained on me at that time that everything has a spirit inside. So I think that it's inappropriate to say that it's okay to have a sacred place, all right? But it's also okay to throw that sacred place around on the roads. Because if every little pohaku, aya he uhani I loko o na pohaku a pauloa. There's a uhani inside every piece. So when we kiloi ika pohaku, we are doing a hanaino to the mountain. I don't like that either.
Thank you.
Other questions? Other questions at this time? We may have more later. I guess I don't know if UH signed up to testify, but does anyone have questions of UH that would relate to Mr. Chin's testimony, or are you ready to just go into regular testimony?
I have one more, please. I'm just looking for some options.
Right.
And, besides these rules, if we have an overlapping DLNR and, management team, is it possible for them to police it, to put a station up and monitor the people coming in? Somebody goes after and takes a look at it, and cite them as such, in the term, what is the total build out of this telescope?
Maybe, I mean, that would be a good question for UH, but I think the other thing is the jurisdiction that they have is, as far as the comprehensive management plan is concerned, is that ability to close the road if they need to for security, for public safety purposes. So that's what's happening. I was saying security because I think your other question was whether or not they can have their own security to be able to do that. And I think that's a good question to ask them, because I think that, what I will say and what's happening there is that there is a difficult time to being able to properly enforce the rules, and so that's why we're asking for these emergency rules to be passed. Thank you, sir.
So, as far as how come the rangers don't have arrest powers, that's a question we should ask the university?
Yeah, it's, in other words, the Rangers aren't, they're not law enforcement. Right, so they're not law enforcement.
Well,
Yeah,
well, I
right.
understand they're not law enforcement
Right.
right now, but
Right.
if they have Kuleana to be up there and stop traffic and whatever, and traffic don't want to stop, what do? You know, call Hilo Station? You know, it's a pilikia.
Or
I mean, what if there's an emergency situation where there's some bad acts going on somewhere on top of the mountain, and somebody sees that, and the only person who's available is the ranger staff? What are they gonna do, just blow their whistle? You know? We have to upgrade the performance on the mountain and not just leave it to the do-care officers
Right.
and the police. The university has some very fine people. I see my friend Chancellor Straney here. I think he's doing a good job. But we need to have law enforcement powers. So the Board of Regents need to take a look at the rules about giving their staff, or whoever makes those rules, to give them police powers so that they have a full assortment of tools so that they can do their job more effectively, and they will garner more respect by the public when something happens up there. You cannot have, oh, you go up here, everything's fine, and then you go up here, everything is no more nothing.
Right.
So we need to take a close look at that. People complain that we're not doing a very good job as stewards of the mountain, and there's some merit to that. And because we're all in it together, we gotta all try harder.
Thank you, sir.
Thank you.
So I did ask some questions about how Office of Monetary Management would handle certain situations. So maybe for those questions that I asked, it would be good to hear from them. But sort of an overlap between something that you had mentioned as well as thinking on the UH side and the Office of Monetary Management side. In terms of I think, I'm not going to get your words correct, but that the volume has increased to a level that's posed challenging and is
Correct.
difficult. And maybe that's just something we didn't expect as those that have Kuleana in that place. But it is kind of common for sacred sites, when there are certain events that happen that belong to those people, that certain areas have an increase in those coming to those places to have certain practices and traditions for a period of time. And so maybe we just need to recognize that this is one of those times for us as a Lahui, and therefore there is going to be that increase that comes at certain places across the Pai'aina. So yes, it's happening at Mauna Kea, but it's also going to happen at other sacred spots around the Pai'aina, as is normal of many religions. So not so much a question, but just, yes, there has been an increase, but I think, and maybe we didn't expect it or for it to last that long, but
Right.
Maybe something for us to consider when we have Kuleana for that type of sacred site, that we are going to experience those pulses when, as a Lahui, we're feeling the need to have that sort of connection. So not necessarily helps us today in terms of being prepared for that, but something that we can keep in mind because that's the kuleana that we all have.
You know, Lewis, I'm with you on that. I think you're right. It's an unforeseen set of circumstances. Well, not unforeseen, but it's a not common set of circumstances that has come up. And so, in the same sense, then from a public safety standpoint, there has to be a sort of balancing that occurs just to be able to keep that in mind. Really quick is that I went up there last week and I went beyond the visitor center to the area where the first switchback was, just to see where the place was where the obstruction was taking place, and then right before the rocks occurred. I was on the gravel road, it was very steep, and I got to tell you, that place, just imagining trucks and hundreds of people standing around and workers and dome care officers trying to take care of the situation, children, older people in that area, all I could think to myself was just how unsafe it was. It was just, there's no guardrails. Anybody who was there on the sides, if something had moved over, they could have fallen off. There were people above the hill. The rocks could have come down. There were so many things that were unsafe from that excessive. And so from a public safety standpoint, that's where I come from. Thank you.
I'd love to hear
Chairman,
from
I just cite the Attorney General a case for you folks to take a look at. Bill Weinoff brought this case to my attention, and I read it, and I think that you need to take a look at it. It's Ling versus Northwest Indian Cemetery Protective Association, 108 Supreme Court, 1319, 1988 U.S. Supreme Court decision. It has an extensive discussion about the relationship between the First Amendment right to worship and the government's right to manage the property. And I think that it's useful to read that, to understand the mix, what we have going on that Member Ululia just brought to your attention, because they come together right in this case, been decided already.
Thank you, sir.
Thank you. Any other questions? Okay, I want to ask if anybody has any questions of UH for starters, or should we just move to?
I have that one that I'd love to hear.
Right.
If the department, and our intent is that it's predominantly open between 4 a.m. and 10 p.m. if the rules get passed, and if the department would like to give a religious permit outside of those times, especially because we're coming into a significant time, how might that be handled, and how have those requests been handled by Office of Monarchy Management, and how would it be handled going forward during this 120 days?
And I'm Chancellor Don Strand of UH Office of Monarchy Management reports to me. We have been very accommodating of people who have wished to engage in cultural practices for the whole time we've been up there, and most particularly recently. The rangers have bent over backwards to find ways to assist people to engage in the practices they want. They negotiated with the people on the ground an agreement to escort folks up the road, which is still not entirely safe for public travel, so that they could engage in those practices. We're constrained by the number of staff we have in terms of how much we can do. Our lease comes from Blnr. If the department wishes to grant permits for particular things, we would certainly work with the department on the ability to exercise those.
Thank you.
Any other questions? Good. Thank you. All right, we're going to move to public testimony, and first we're going to have